Hello, everyone. Welcome to Navigate Home. This is the fourth installment of the series. For those of you who are not familiar with Navigate Home, it's a group of local professionals that serve the senior community. And so, great group of resources as people age. There's questions, and it's a great team of trusted individuals that can help people transition through that period of their life. We currently go live every Tuesday and Thursday. So Tuesdays is at noon, Thursdays is at 7 p.m. My name is Mike Rutkowski. I'm the owner of the Rutkowski Law Firm. We specialize in estate planning and elder law. So today we're going to talk about some of the really important things that people should be thinking about right now when there's either a crisis like we're all going through together, or a crisis at home where it might be a situation where health is declining, something new has changed, and we're going to kind of all tie that in together because a lot of that's all happening simultaneously right now. And there poses a lot of challenges when the certain planning isn't in place. So we're going to kind of jump into a little bit about estate planning. I'm going to be trying as best as I can to watch the comments to see if there's anything, any good questions that come about, and I'd be happy to answer questions as we go along. So kind of let's start with some of the hot topics right now, or things that we're getting the most calls about, and that really has to do with powers of attorney. And so what we're talking about is incapacity planning. You know, what happens if an individual can't make decisions for themselves? And what becomes incredibly challenging at the moment is, in the past, we could go get appointed as someone's guardian or conservator. Thanks, Valerie. I see you there. We could go get appointed as someone's guardian and conservator through the court system. Essentially, if someone can't make decisions for themselves, they're deemed incapacitated by a physician, and now they can no longer do things for themselves. We could go to the courts if they had no planning in place and get appointed as their guardian, who takes care of the physical well-being of an individual, or their conservator, or both. The conservator takes care of the financial end of things. And so what's happening right now is, as you may or may not have heard, the courts are closed. So with the courts being closed, it becomes incredibly difficult to get a hearing. We can only do so in a super emergency type situation. Just because someone's house is for sale and you can no longer close on the sale of the home because you don't have power of attorney or guardian for an individual is not going to become an emergency. So it's really a delicate situation right now with the court systems being closed, which just further then makes us all realize how important that kind of planning is. So let's kind of circle back now. So I mentioned incapacity planning, and we're talking about powers of attorney. Those are the things I could help you with. And there's a financial power of attorney and a medical power of attorney. Both those documents give you, the individual, the ability to appoint someone else to make medical or financial decisions for you. A big misconception that a lot of people feel is to be true is that a spouse has those abilities to make those decisions for you if, let's say, there was an unexpected car accident or dementia or something has set in where you can no longer make those decisions. A spouse doesn't have the ability to do that just because you're married. So even in a married type situation, we're still going to the court to get you appointed as that person's guardian. Now, the difference is if there's joint accounts, right? If there's a joint account at Chase Bank, then both individuals have 100% access to that account. So you're not actually acting for that person. You're just transacting or doing something on an account that you are already the owner of. So just to be clear, it's those situations where there's something in someone's name alone, maybe a vehicle, maybe they have a cell phone that we no longer need to use anymore. Well, it's impossible to call up Verizon and say, hey, we don't need this cell phone anymore without that power of attorney in place. They're just not going to talk to you. So it can become incredibly important to do that. Also, what it really gives you the ability to do is control, one, who the people are, because it gives you the ability to say, who do you want first in charge? And if that person can't do it, who's the backup to that person? If we go in court, a judge is going to spend all of 3 to 5 minutes on your case. There's an order of priority in the statute, which might not be exactly what you want, but they're just going to pick according to, according to that, what the statute says. And it might be an order of your kids or spouse or whoever that you don't want. If you have no spouse or kids, it might be a situation where they're appointing a sibling. Well, maybe you don't really get along with that sibling. And maybe you don't think they'd make good medical decisions or financial decisions for you. So the great thing about these power of attorney documents is just that you get the ability to choose who that person's going to be. Taking that one step further, you have the ability to say what power you're giving them. So with a financial power of attorney, you can just give a blanket authority to say they can do everything I could have done. They can essentially step into my shoes and do anything I could have done. Or we could really limit the power of attorney. We could say they're allowed to do X, Y, and Z, but they're not allowed to do A, B, and C because you don't have that comfort level with them, or it's just something you don't feel comfortable delegating. So those are the things that the things we walk through when we're doing power of attorney planning with someone, is all those important things. This is where the online kind of just filling out the form is really missing that legal guidance, because this is where you could just give a total blanket authority to someone that you didn't want. And just understanding what authority it is that you're giving to someone is incredibly important. So let's go now next to the healthcare power of attorney. So this document has, it goes by a bunch of names. You'll hear it be called a patient advocate designation, a healthcare proxy, all of which are the same. In Michigan, under the statute, we call it a Michigan healthcare power of attorney. But this is the document that you're going to do a couple things. You're going to nominate who are going to be the people that can make the important decisions for you. And this is everything from things that are simple, like who's going to pick up my prescriptions and the ability to do that, to end of life decisions if it comes to like when should we pull life support, essentially pull the plug, for lack of a better way to describe it. But there's a wide range of decisions or things that a medical power of attorney can do for you. So again, walking through what do I want them to have the authority to do? Furthermore, a good healthcare power of attorney covers something called a living will and a HIPAA authorization. So the living will is your decisions when it comes to, if I were in a coma or vegetative state, what type of life support I would want. And the nice thing about, or nice I wouldn't say is the best way to describe it, but the good thing about this is the better job you do laying out what your wishes are, who you want to make those decisions. Typically, if we're ever in a place where we need to use this healthcare power of attorney, there's usually a lot of, it could be emotional, it could be, it's a grieving time. If you have to make the decision whether to pull the plug from someone, it's not an easy thing to do. And if that person has laid out to you specifically, if these things happen, I do not want artificial life support, it makes that situation just that much easier on the person that you've put in charge of doing it. Because if you just give them blanket authority to just make decisions for me, but not giving any direction as to what those decisions are, that can put someone in a very difficult spot also. So there's lots of options when it comes to your healthcare power of attorney and that living will section of when you no longer want artificial life support. So it's really good to thoroughly go through that. Next, which has been a more recent topic, is the HIPAA authorization. So this is, we've probably all heard about protected medical records and information. So what this does is it gives you the authority to delegate that power to someone to have access to your medical records and information. What can be very valuable here is, let's say someone's traveling maybe to their second home, even though they're not allowed to do that right now, but they're headed farther away from home than just somewhere local, and they get in a car accident, and now they're admitted to a hospital nearby. Well, even being a spouse related, you can't find out what happened to that person over the phone. You might get a call at best and say, hey, this person is here, but it's going to be a long car drive from you to that person wondering what happened, where that HIPAA release gives the ability for that person to disclose information over the phone. So that can be very beneficial. Another thing this is really good for is for college age students. Healthcare and financial powers of attorney, we do a lot for college age students because while they're still in the home, it's a lot easier to get them to agree to delegate those powers to you as a parent, because usually they're over 18 and now you've kind of lost control. So they go away to school, maybe they're at Michigan State, Michigan, or Western, go Broncos. And you need to, you want to find out, maybe they were hospitalized there. You find out what's going on because Western's 2.5 hours from Southeastern Michigan. Or you're the one who pays the tuition, but you can't find out how much is actually owed because you don't have that power of attorney in place. So it can be very beneficial to have those powers of attorney, not only because usually we think about it in a older capacity, but younger too. I mean, if they're 18, 19, 20, it'd be great for a parent to have those powers of attorney so that they could help manage their kids' affairs if they're still involved with their life. So that would make a lot of sense. So let's talk about now, we've talked about powers of attorney. Let's talk about a little bit more on what happens if you don't have that in place. So in a typical environment, when we're not dealing with everything that we're dealing with right now, we'd have to go to court to get appointed as a guardian and conservator. So typical, fees and court costs on that can be anywhere from $2,500 to $10,000 plus if the kids are all fighting over who's going to be the power of attorney. And this takes time. So anytime we're involved with court, which is typically a big goal of ours to keep people away from court, keep their matters private, make things happen easier, more fluid. If we're in court, it's just expensive and it's time consuming. It could be weeks before you get in there for a traditional guardianship hearing if there's no emergency tied to it. So it's just time we're sitting on. If we need to move, mom or dad into a home and we don't have the authority to do that because we don't have powers of attorney and we need guardianship, there's another 3 weeks that we could be waiting before we get that appointment in place. But moving forward, if you needed to go that route and once you get appointed as a person's guardian, you're going to get something called letters of authority. These are essentially the documents you're going to show every financial institution or anyone who needs to know that you have the ability to act on that person's behalf. So once you have those letters of authority, you can pretty much do everything. And it's similar with the powers of attorney also. I mean, pretty much how it usually works. I was just asked this morning, now I have these, what do I do with them? As soon as you try to act on someone's behalf and you're not the person, they're always going to ask you, well, do you have power of attorney? And you're going to want to, fax, email, however you can get those in their hands, always making sure to give a copy, never the original. Okay, that's super important. I was asked that this morning as well. Keep the originals for yourself. We typically keep a backup copy just in case something were to happen to yours, or you want to call our office and have us email it off to someone. We can easily do that, but you hold on to the originals. Institutions get the copy. Okay. A little bit more downside of the whole court process, if you need to be appointed as someone's guardian, is that there's going to be annual oversight by the court. So what I mean by that is every year you're going to have to go in and renew your guardian conservatorship. You're going to have to provide receipts for the things that you've paid for. There's just way more court involvement, more fees, more everything once we have that guardian and conservatorship. Although a financial power of attorney is still held to a fiduciary standard, there isn't nearly as much oversight. More so, as soon as anything looks fishy, someone can say, hey, what's going on? And then we'll involve the court to kind of have you then provide receipts or do something like that. But if everything seems pretty straightforward, it's one of the kids working for mom and dad, none of the other kids are suspecting anything funny, it's very easy process to act as someone's power of attorney. So those are probably the hottest topics right now. One of the offers that we have is just like a thank you to first line responders, medical professionals, pretty much anyone who's out there that has to be at a risk because they're still out in the community serving. We're doing free healthcare powers of attorney for any first line responders. So just reach out to the office. We can do it through Zoom. I mean, we're doing meetings like this all day. So, at your convenience, I know everyone's working lots of hours right now. We can schedule evening meetings. So we've been able to do that. Yes, Kim, totally. POAs, super misunderstood. And one other point I want to make on this, and this is just for my healthcare providers out there, or anyone who's on the other side of a power of attorney, someone who's been provided a power of attorney. Usually someone has an order of people, and they're usually in successive order, meaning son John first, daughter Sally second, right? You're not supposed to, if you can't get in touch with John, you're not supposed to call Sally. It's not until John actually resigns his position as power of attorney, not able to take it back, before it goes to Sally, or John can't act for whatever reason. Maybe he was in a car accident or unfortunately passed away or something where it doesn't allow him to act. Then it would go to the next in line. This is not a list of people where if you try calling the first one and you can't get in touch with them, you just start going down the list. And I've actually stood there one time in front of someone as they did that, and I was like, would it be okay if I review that and just make sure you're doing what you're supposed to be doing? And I just don't think there's a lot of good education around that. A lot of times people see 1, 2, 3, so they're like, okay, if I don't get a hold of 1, I call 2. If it's not 2, then 3. So that's just for the people who are in a position to receive powers of attorney, bankers, nurses, all those people who deal with those. So that's powers of attorney. That's incapacity planning. Let's talk for a minute. How are we doing on time? We're doing good. Let's talk a little bit of the next biggest or most asked question at our office is, what is the difference between a will and a trust? So I think it'd be important to kind of just dive into that because everyone wants to know. So there's typically 4 big differences between wills and trusts. The first one is that a will still goes through the probate process and a trust avoids probate. So circling back to the conversation on powers of attorney, there's costs and time that come along with going through probate, plus a lot of headache. But it usually costs between 5 and 10% of the value of the estate. So if there's a house that's $100,000, it's going to cost somewhere between $5,000 and $10,000 to walk through that probate process with just that one asset. So do a total value of assets that are in someone's names personally, and that's what it's going to cost to go through probate. Secondly, it usually takes between 9 and 18 months to go through that probate process. So what that means is that assets are kind of froze for a moment. We can pay some last known expenses and funerals and those kinds of things, but distribution of assets, it's going to be a while. You have to wait through something called the notice period to creditors. And then what that means is, let's say there's that house. We have to keep that house until a judge says we can get rid of it. And so that means the snow that's out there falling right now today, yes, it's April 21st and it's snowing out there. Not that there's going to be enough to shovel, but my point is you have to do the maintenance on the house. You have to shovel snow. You have to cut grass. You have to pay the taxes. You have to do all those things until you can finally sell the property that's sitting there vacant. So with a trust, the successor trustee can jump right in, get the house listed. It's a good market, get it sold relatively quickly. You don't have that headache of dealing with all of that and kind of waiting on a judge to get to your turn to let the house be sold. So next big difference between a will and a trust. So just circling back, will goes through probate, trust does not. Secondly, a trust is a private transaction and a will is a public document. Where this becomes really important, well, let's go with the not so important first, that's just more entertaining. So celebrities who do terrible estate planning or no estate planning, we get to see how many millions they had, who got what, who's fighting over the super fancy expensive shoes. I mean, we get to see it all, and it's all just public record, and People Magazine's going to report about it all day. Now you're probably like, well, okay, no one's going to care about my $35 Converse. But my point being is what it does is it invites the family in to say, hey, I think I deserve more than he or she did because maybe I took care of this person at the end of their life. Or, towards the end there, they verbally told me I got more than I'm getting through this estate plan. There's got to be other documents or something. So as soon as everyone starts contesting it, now it's that 9 to 18 months becomes 3+ years. Everyone's got to have their own attorney. So now we just wasted a third of the estate just, fighting over the nonsense. Where in a trust, as the beneficiary, you get to find out what you got, and that's really it. It just keeps family peace so much more. I can't tell you how many times I've seen families ripped apart, clearly over money, because they went through the probate process. So third big difference between a will and a trust is you can be a lot more flexible in your planning in a trust versus a will. A will is pretty much like, here is your share, good luck to you. With a trust, you can say things like, if there's young kids, you could say something like they can use it for education, medical bills, those kinds of things, but they can't use it like an ATM machine until they're 30. Maybe we give them half at 30, half at 35. Truly in a trust, you can get as creative as you like. In a will, again, it's just like, here you go. And then the fourth and final difference between a will and a trust is we can protect assets in a trust. We cannot protect assets through wills. So a will just being a really good suggestion to a judge. He's just going to do what it says typically as soon as he gets to your case. And that doesn't matter if the beneficiaries are in the middle of a divorce, they were in a car accident and are sued, they're in long-term care. It doesn't matter. Whatever the will said, judge is like, here you go. So there's kind of two ways we can protect assets in a trust. We can protect assets for the beneficiaries, which would look like, let's say one of the kids is in the middle of a divorce when the parent passes. We can hold those assets in the trust if it's properly written to delay that distribution until the bad thing happens in that person's life. That goes away. Now we make the distribution and the child beneficiary gets 100% of what we intended them to get. Okay. We can protect against all kinds of things. Drugs and alcohol are a big thing right now. Divorce, lawsuits, you pretty much name it. We don't have a crystal ball to look into the future to say what's going on in all of my beneficiaries' lives when I pass. So this is kind of like a way to do that. We can build in protection for your beneficiaries to make sure they get what you wanted them to get when it makes sense and is appropriate for them. I think we just got a question. Let's see if I can manage this here. Good question. So the question was, and I lost my video here. There we go. Is there a recommendation of at what age you should set up a trust? And that's a great question. I'm going to take that one step further because I get asked this all the time. A lot of families think it ties to a certain asset level, like a certain net worth. And truly, it just really depends on the situation. It all depends on what we're trying to accomplish. A trust is a tool, a will is a tool. And depending on what your goals are, determines what tool works best, okay? Typically, to me, the key points in someone's life where a trust starts making sense is one, if there's young kids in the picture, because through a will, there's going to be a way too early of a distribution. They're going to buy things that they shouldn't. We could set up a super simple trust that just says, okay, even though I don't really have anything, if I pass away, my life insurance will fund this trust that says, use it to take care of these kids as I would have, education, medical bills, all those things, and it distributes to them later in life. It can be very simple to do something like that. It doesn't have to be a super complex trust to do that. So that usually is one of the early points where it's like, for sure, if there's kids in the picture, that makes a ton of sense. The other thing is if there's real property. So if we're talking about you own a house, you own any timeshares, any second properties, anything like that, that's where trust starts making a lot of sense, because we can transition those assets and have control over them so that they don't have to go through probate. Because there's without a trust or using a ladybird deed, there's no way to get that property to avoid probate. And as soon as that's wrapped into probate, it's off to the races with everything else and the ability for people to contest things. So really good question there. And then, so I was talking about protecting your assets for your beneficiaries. That's through certain types of, we can do that in standard revocable trusts. These are probably what 99 out of 100 people you talk to have. And then there's trusts that can protect your assets during your lifetime. So from things like long-term care costs, utilizing Medicaid planning to do so, from lawsuits, from creditors. We can do all those kinds of things in an asset protection trust, which is more similar to it is a style of irrevocable trust. It's not your your tax planning irrevocable trust from years past where you put everything in it and you're never touching it again. It's a much more flexible irrevocable trust. So I know people kind of get scared by the term, but it's relatively flexible. And if you need the assets, you can get to them. So I'm sure I'll talk again at some point here as we stay quarantined for the next who knows how long. I'll come on and do quite a bit on long-term care planning. Let's see, I think another question just came in. Oh, just a really good point by Kim. Yeah, just stay away from the online stuff. I cannot tell you how many times someone has come in with one that they've done on LegalZoom or something, and they just put all the things in the wrong spots. You really need a little bit of guidance while going through that process. And what they did accomplished nothing from what they wanted to do. So, with that being said, we're always more than happy to review current estate plans as well. So if you did an online one, that's okay. We can fix it. It's kind of like Great Clip haircuts, but we all wish they were open right now. Nothing's open. So got to cut your own hair. I think I'm going to wrap on that. I don't see any other questions unless there's any others coming on in. We talked a lot today about powers of attorney and incapacity planning. We went through the basics of estate planning, talking about powers of attorney, will, trust, the differences. I think I'll use the opportunity in the next go around, if we're all still stuck working from home, to really dive into the long-term care. So let's see here. I think I have on my list who is up next. So I think on our next go live session, which might be this Thursday at 7 o'clock. Yes, it is. Annette Werner, certified dementia practitioner with Comfort Keepers Home Care. So she's going to be live this Thursday, April 23rd, 7 p.m. So please tune in to that. Share this with anyone who could find value in the information that we're sharing as a group. If anyone needs any of our services or has questions, please feel free to reach out to the group, and we're here as a resource for the community. So thank you everyone for having me. Have a great day, and we will talk to you soon.